Okay, reading module 13 through 16, and 13 is about strict liability, liability without fault, liability for animals, domesticated animals. An owner is not strictly liable for injuries caused by domestic animals, including farm animals, unless they have knowledge of that particular animal's dangerous propensities that are not common to the species. Injury caused by the normally dangerous characteristics of domestic animals, for example, bulls or honeybees, does not create strict liability. Trespassing animals, an owner is strictly liable for reasonably foreseeable damage by a trespass of his animals. Wild animal owner is strictly liable to licensees and invitees for injuries caused by wild animals, even those kept as pets. Strict liability not available to trespassers. Strict liability will generally not be imposed in favor of to recover for their injuries from a wild animal or abnormally dangerous domestic animal. A trespasser must prove the owner's negligence. Abnormally dangerous activities. Courts generally impose two requirements for finding an activity be abnormally dangerous. The activity must create foreseeable risk of serious harm, even when reasonable care exercised by all actors. The activity is not a matter of common usage in the community. Common examples of abnormally dangerous activities include blasting or manufacturing explosives, storing or transporting dangerous chemicals or biological materials, and anything involving radiation or nuclear energy. As with negligence, the defendant's liability extends only to foreseeable plaintiffs. Also, the harm may result from the kind of danger to be anticipated from the dangerous activity or animal, including harm caused by fleeing from perceived danger. Strict liability does not apply when the injury is caused by something other than the dangerous aspect of the activity. For example, a dynamite truck suddenly blows a tire and hits a pedestrian but does not explode. Products liability is going to be the next section, but just want to read about wild animals first. Owner is strictly liable to licensees and invitees for injuries caused by wild animals, even those kept as pets. But the strict liability is not available to trespassers, and they'll need to prove the owner's negligence in that case to recover. So, products liability. Products liability refers to the liability of a supplier of a defective product to someone injured by the product. Theories of liability. There are 5 theories of liability. It just keeps getting longer that plaintiff may use. 1 is intent. 2 is negligence. 3 is implied warranties of merchantability and fitness for a particular purpose. 4th, representation theories, express warranty and misrepresentation. And 5th, strict liability. Elements for strict liability. To find liability under strict liability theory, the plaintiff must show the defendant is a merchant, in other words, a commercial supplier of the product. The product is defective. The product was not substantially altered since leaving the defendant's control. The defendant was making a foreseeable use of the product at the time of the injury. Only merchants can be held liable. Any commercial supplier can be held liable. Does not extend to casual sellers, does not extend to services. Strict products liability applies only to products. Even when a product incident to a service, for example, blood during an operation, there is no strict liability. The plaintiff may, however, sue in negligence. Includes commercial lessors. Most states include commercial lessors. In other words, those who rent rather than sell products also can be held strictly liable. Includes entire distribution chain. Commercial suppliers include manufacturers, wholesalers, and retailers. Privity is not required. Users, consumers, and bystanders can sue. types of defects: manufacturing defects, design defects, information defects. If a product emerges from back to manufacturing defects, I just lost enough memory to open the page. I was looking at manufacturing defects on page 48. If a product emerges, this is in the strict liability, products liability section. If a product emerges from manufacturing different from and more dangerous than the products that were made properly, it has manufacturing. The defects will be, the defendant will be liable if the product can show that the plaintiff can show that the product failed to perform as safely as an ordinary consumer would expect. The defendant must anticipate reasonable misuse. Note, this also applies to defective food products. Designing defects. When all products of a line are the same but have dangerous propensities, they may be found to have a design defect. Manufacturers will not be held liable for some dangerous products, for example, knives, if the danger is apparent and there is no safer way to make the product. The plaintiff usually must show that the defendant could have made the product safer without serious impact on the product's utility or price. This is referred to as the reasonable alternative approach. Government safety standards. A product's non-compliance with government safety standards establishes that it is defective, while compliance with safety standards, including labeling requirements, is evidence but not conclusive that the product is not defective. Information defects. A product may be defective as a result of the manufacturer's failure to give adequate instructions or warnings as to the risks involved in using the product that may not be apparent to the users. For prescription drugs and medical devices, warnings given to learned intermediaries, for example, the prescribing physician, will usually suffice in lieu of warnings to the patient. So what's key to know here is for design defects, you have defendant could have made the product safer without serious impact on the product's utility or price. For manufacturing defects, this is the plaintiff shows that the product failed to perform as safely as an ordinary consumer would expect. Government safety standards are probative as to the design defects argument. And then for information defects, you want to get to adequacy. That wasn't part of this. Failure to give adequate instructions or warnings as to the risks involved in using the products that may not be apparent to users. So it's not apparent. Existence of defect when product left defendant's control. The plaintiff must show that the product has not been significantly altered since it left the defendant's control. If the product moved through normal channels of distribution, it will be inferred that the product was not altered and that the defect existed when the product left the defendant's control. Misuse of product may be foreseeable. The plaintiff must have been making a foreseeable use of the product at the time of the injury. A defendant will not be held liable for dangers not foreseeable at the time of marketing. Nature of danger, damage is recoverable. Physical injury or property damages must be shown. Recovery will be denied if the sole claim is for economic loss. Disclaimers ineffective. Disclaimers are irrelevant in strict liability cases if personal injury or property damage occurs. Other products liability theories. Liability based on negligence. Negligence in a product's case is proved the same as in standard negligence case. The plaintiff may invoke re ipsa loquitur if the defect is something that would not usually occur without manufacturer's negligence. Note that it is very difficult to hold intermediaries such as retailers and wholesalers liable for negligence because they can usually satisfy their duty through a cursory inspection. In addition, as intermediaries, negligent failure to discover a defect does not supersede the original manufacturer's negligence unless the intermediary's conduct exceeds ordinary foreseeable negligence. So that's one of the other theories. That's the negligence theory. So I feel like going backwards, just to understand, okay. We had talked about the types of defects in product liability, strict product liability, and as manufacturing design and information. Then C came up, which was the existence of the defect when the product left the defendant's control. This was still under the strict liability section. Same with misuse of product may be foreseeable, nature of damage is recoverable, and disclaimers ineffective. So all of those letters elaborate upon strict product liability. So here's your, we talked about negligence on page 50. There's a chart on page 51 for products liability theory, which may be worth just printing this page. Negligence, strict liability, and implied warranties, which I have not really ever seen how implied warranties, I mean, besides like one recent essay I was reading, I have not tried to use a warranty theory for product liability. So it will be interesting to see that in this table. Who can sue? A purchaser and their family, household, and guests can sue under implied warranty product liability theory. Who can be sued? For implied warranty of merchantability, the merchant dealing in goods of the kind. For fitness for a particular purpose, any seller of the goods. What constitutes culpable conduct? For the implied warranty of merchantability, sale of goods is not generally acceptable or fit for ordinary purposes. That's culpable conduct. And whereas for implied warranties of fitness for a particular purpose, the standard would be the sale of goods is not fit for the purpose that the seller knows or has reason to know and knows that buyers are relying on the seller's judgment. What damages can be recovered? This is personal injury and property damages. Recovery solely for economic loss also is permitted. That is what distinguishes this implied warranties type of products liability theory from negligence and strict liability, because there are no recovery for economic loss standing alone in negligence and strict liability. There is, however, personal injury and property damage remedy under a negligence and strict liability product liability theory. And what defenses are available, say, for instance, to the manufacturer or the product supplier or the commercial supplier? You have contributory negligence states and comparative negligence states. So for contributory negligence, the assumption of the risk and reasonable misuse and failure to give reasonable notice of a breach is a defense, and secondarily, in comparative negligence states, any type of fault under the state's comparative negligence rules would be an available defense. In negligence, we just went over who can sue is any foreseeable plaintiff who can be sued, any product supplier, usually a commercial supplier such as a manufacturer, wholesaler, or retailer. What constitutes culpable conduct? Negligent conduct that results in the supplying of a defective product. What damages can be recovered? Personal injury and property damage, no recovery for economic loss standing alone. And what defenses are available? Assumption of the risk and any type of contributory or comparative negligence according to the rule generally applicable to negligence cases in that state. For the section I had read before negligence, the strict products liability section, any foreseeable plaintiff can sue any commercial supplier, and what constitutes culpable conduct is supplying a defective product. The damages to be recovered, I just spoke about personal injury and property damages, but there's no recovery for economic loss standing alone. And the defenses that are available are broken into contributory negligence states and comparative negligence states. they are the same for comparative negligence states as they are in implied warranties, which is that any type of fault under the state's comparative negligence rules would serve as a defense, whereas contributory negligence states, assumption of the risk and unreasonable misuse are defenses. A failure to discover or guard against a defect is not a defense. Let me try printing that. There's a lot of knowledge there. On this page, significantly altered since it left the defendant's control. If the product moved through normal channels of distribution, it will be inferred the product was not altered and that the defect existed when the product left the defendant's control. Misuse of product may be foreseeable. The plaintiff must have been making a foreseeable use of the product at the time of the injury. The defendant will not be held liable for dangers not foreseeable at the time of marketing. Did I already read this? I did already read this. Did I? Yeah, and then I read other products liability theories. Okay, so we're on page 52 now. Who can sue under negligence theory? Privity with the defendant is no longer required, so any foreseeable plaintiff can sue. Nature of damages recoverable. Physical injury or property damage must be shown. Recovery will be denied if the sole claim is for economic loss. Disclaimers ineffective. As with strict liability, disclaimers are irrelevant in cases based on negligence if personal injury or property damages occur. Implied warranties of merchantability and fitness. There are 2 warranties implied in every sale of goods that can serve as the basis for a suit by a buyer against a seller, including merchantability, which refers to whether the goods are of average or acceptable quality and are generally fit for the ordinary purpose for which the goods are used. Goods that are likely to injure users, even when handled properly, are quite obviously in breach of this warranty and will subject the seller to liability. Fitness for a particular purpose, which arises when the seller knows or has reason to know the particular purpose for which the goods are required and that the buyer is relying on the seller's skill and judgment in selecting the goods. Who can sue? Most courts no longer require vertical privity. Most states adopted a narrow version of the horizontal privity requirement. This means the buyer, family, household, and guests can sue for personal injuries. These warranties also generally apply to a lease of goods. What constitutes breach? If the product fails to live up to either of the above standards, the warranty is breached if the defendant will be liable. The plaintiff does not have to prove any fault on the part of the defendant. Causation, actual cause, and proximate cause are handled as in ordinary negligence cases. Damages, personal injury, and property damages and purely economic loss are recoverable. Defenses. Defenses include assumption of risk and using a product while knowing of breach of warranty and contributory negligence to the same extent as in strict liability cases. Failure to give notice of breach is a defense under the UCC, even in personal injury cases. Effective disclaimer. Disclaimers are generally rejected in personal injury cases but upheld for economic loss. Representation theories. A defendant may be liable when a product does not live up to some affirmative representation. The 2 representation theories are express warranty and misrepresentation effect. I'm going to add those to this table because they really weren't there, but there's nothing really stopping me from expanding this table for these, quote, representation theories of express warranty and misrepresentation of facts. Express warranty. Any affirmation of fact or promise concerning goods that becomes part of the basis of the bargain creates an express warranty. An express warranty may also be created in a lease of goods. Who can sue? Any consumer, user, or bystander can sue. If a buyer sues, the warranty must have been part of the basis of the bargain. If the plaintiff is not in privity, for example, a bystander, they need not have relied on the representation as long as someone did. So any consumer, user, bystander may sue. But what is it? Affirmation of a fact or promise concerning goods that becomes the basis of the bargain. Next page, 54, breach. Fault need not be shown to establish breach. Plaintiff need only show the product did not live up to its warranty. Causation, damages, and defenses. Causation, damages, and defenses are treated just as they are under implied warranties. Disclaimers. A disclaimer will be effective only in the unlikely event that is consistent with the warranty. Misrepresentation of fact. A seller will be liable for misrepresentation of facts concerning a product where the statement was of a material fact concerning quality or uses the goods mere puffery insufficient. The seller intended to induce reliance by the buyer in a particular transaction. Liability is usually based on strict liability, but may also arise for intentional or negligent misrepresentations. Justifiable reliance. Justifiable reliance is required. In other words, the representation was a substantial factor in inducing the purchase. Reliance need not be the victim's, it may be a prior purchaser's. Privity is irrelevant. Causation and damages. Actual cause is shown by reliance. Proximate cause and damages are the same as for strict liability. Whereas here in the express warranty, they were the same as implied warranties. The damages and the defenses and the causation, actually. But now in misrepresentation, they're the same as negligence. At least the damages and defenses are. Justifiable reliance is required. In other words, the representation was a substantial factor in inducing the purchase, and reliance need not be the victim's, it may be the prior purchaser's. Privity is irrelevant. So I'm going to put reliance here in what constitutes culpable conduct, whereas in this one it was kind of basis of the bargain. It's probably the same for them both. Defenses. Assumption of risk is not a defense if the plaintiff is entitled to rely on the knows as if the plaintiff is entitled to rely on the representation. Contributory negligence is the same as strict liability unless a defendant committed intentional misrepresentation. Affirmative defenses. If contributory negligence states, contributory negligence is no defense if the plaintiff has failed to realize the danger or could guard against it. It is a defense if the plaintiff knew of the danger and their unreasonable conduct was the very cause of the harm from the wild animal or abnormally dangerous activity or defective product. Assumption of the risk is a good defense to strict liability. Many comparative negligence states apply their comparative negligence rules to strict liability cases. And so assumption of risk is not a defense to misrepresentation of fact. What they said the defenses are is coming from the strict liability section, which had contributory negligence and comparative. I just read affirmative defenses. I think that's in general. Assumption of risk is a good defense to strict liability. Many comparative negligence states apply their comparative negligence rules to strict liability cases. Okay. So that was just a general statement. So we moved into Module 14, which is nuisance. A nuisance is an invasion of property rights by tortious conduct. There are two types of nuisance, private and public. Private nuisance. Private nuisance is a substantial, unreasonable interference with another private individual's use or enjoyment of property that the other individual actually possesses or has a right of immediate possession. Substantial interference. Substantial interference is interference that is offensive, inconvenient, or annoying to the average person in the community. It is not substantial if it is merely the result of the plaintiff's hypersensitivity or specialized use of their own property. Unreasonable inference. To establish unreasonable inference required for nuisances based on intent or regulation, the severity of the inflicted injury must outweigh the utility of the defendant's conduct. In balancing these respective interests, courts take into account that every person is entitled to use their own land in a reasonable way, considering the neighborhood, land values, and existence of the alternative courses of conduct open to the defendant. Trespass to land distinguished. In a trespass, there is an interference with the landowner's exclusive possession by a physical invasion. In a private nuisance, there is an interference with use or enjoyment. And it's substantial, whereas trespass doesn't need to be substantial. It's like the slightest interference. Public nuisance. Public nuisance is an act that unreasonably interferes with the health, safety, and property rights of the community. For example, using the building for criminal activities such as prostitution. Recovery by a private party is available for a public nuisance only if the private party suffered unique damage not suffered by the public at large. Remedies, damages. The plaintiff usually will be awarded damages. Injunctive relief. If the legal remedy of damages is unavailable or inadequate, for example, the nuisance will cause irreparable injury, injunctive relief will be awarded. In this case, the court will consider the relative hardships. However, hardships will not be balanced if the defendant's conduct was willful. Abatement by self-help. In the case of a private nuisance, self-help abatement is applicable or available after notice to the defendant and their refusal to act. Only a public authority or a private party who has suffered some unique damage can seek an injunction or abatement. Defenses. Legal authority, legislative authority for nuisance activity, for example, a zoning ordinance is not an absolute defensive but is persuasive. Conduct of others. No one actor is liable for all damage caused by concurrence of their acts and others. Conduct of others is a defense to public nuisance. So no one actor is liable for all damage caused by concurrence of their acts and others. Contributory negligence. Contributory negligence generally is no defense to nuisance unless the plaintiff's case rests on a negligence theory. Coming to the nuisance, one may come to the nuisance, purchasing land next to an already existing nuisance, and thereafter pursue an action. It is generally not a bar to the plaintiff's action unless the plaintiff came to the nuisance for the sole purpose of bringing a harassing lawsuit. Now, vicarious liability and other miscellaneous considerations, Module 15. Vicarious liability is liability that is derivatively imposed. This means that one person, the acting tortfeasor, commits a tortious act against a third party, and another person, the passive tortfeasor, will be liable to the third party for this act. The basic situations that you should know for bar examination purposes are set out below. There's employer-employee, within which we talk about frolic and detour and intentional torts. The others are independent contractor situations, partners in joint ventures, automobile owner for driver, bailor for bailee, parent for child, tavern keepers, multiple. Okay, so we'll get to multiple defendant issues, but that will be a new section. So that won't be probably, quote, types of vicarious liability. But the one thing that I recently learned about vicarious liability that I never want to forget is that it is not direct liability. So when you're answering MBE questions, that is a distinction that they like to make, is that direct liability is direct. This is vicarious, and when they're testing on vicarious and they say something about direct liability, they are not talking about the same thing. You need to avoid those traps. Employer-employee and vicarious liability type 1. An employer may be vicariously liable for tortious acts committed by their employee if the tortious acts occur within the scope of the employment relationship. This concept is also known as the doctrine of respondent superior. Frolic or detour. So respondent superior is clearly a type of vicarious liability for employer-employee relationships. Okay, it also is not a direct liability. What I mean by that is if the employer did it themselves, it wasn't their employee that did it, then they're directly liable, and vicarious liability is just not an answer to that question. Frolic or detour. An employee making a minor deviation from their employer's business for their own purpose is still acting within the scope of employment. If the deviation in time or geographic area is substantial, the employer is not liable. Intentional torts. It is usually held that intentional tortious conduct by employees is not within the scope of employment. There are exceptions, such as if the employee is furthering the business of the employer, for example, removing customers from the premises because they are rowdy, forces authorized in the employment, for example, a bouncer. Friction is generated by the employment, for example, a bill collector. Liability for own negligence. Employers may be liable for their own negligence by, and this is the direct point I was bringing up. By what, though? Negligently selecting or supervising their employees. This is not vicarious liability. Independent contractor situations. In general, the hiring party, the principal, will not be vicariously liable for the tortious acts of the independent contractor. The agent, in parentheses. There is an exception, however, for situations where duty is simply non-delegable due to public policy considerations. For example, the duty of a business to keep its premises safe for customers. Liability for own negligence. The employer may be liable for their own negligence in selecting or supervising the independent contractor. For example, a hospital may be liable for contracting with an unqualified and incompetent healthcare provider who negligently treats the hospital's patient. This is not vicarious liability. Okay, don't fall for it. Partners in joint ventures. Each member of a partnership or joint venture is vicariously liable for the tortious conduct of another member committed in the scope and course of the affairs of the partnership or joint venture. Automobile owner or driver. The general rule is that an automobile owner is not vicariously liable for the tortious conduct of another person driving their automobile. Some jurisdictions, courts have developed exceptions to this rule to hold an automobile owner liable under specific circumstances, such as A, B, and C. A, family car doctrine. B, permissive use. And C, liability for own negligent entrustment. This is another example of not a vicarious liability, when an owner may be liable for their own negligence in entrusting the car to the driver. Some states have also imposed liability on the owner if they were present in the car at the time of the accident, on the theory that they could have prevented the negligent driving and hence were negligent in not doing so. This is not vicarious liability. So go back to the family car doctrine. In many states, the owner is liable for tortious conduct of immediate family or household members who are driving with the owner's express or implied permission. permissive use. A number of states have now gone further by imposing liability on the owner for damage caused by anyone driving with the owner's consent. However, under federal statute, rental car companies are not vicariously liable for the negligent accidents of their customers, even if they do business in a permissive use state. Baylor for Bailey examples. No, actually, there's one more. Driver acting as agent for the owner. The car owner will be liable if the driver is acting as the owner's agent, for instance, using the car to perform an errand for the owner. Baylor for Bailey. Under the general rule, the bailor is not vicariously liable for the tortious conduct of the bailee. There is a negligent entrustment. As above, the bailor may be liable for their own negligence in entrusting the bailed object. This is not vicarious liability. Parent for child. A parent is not vicariously liable for the tortious conduct of their child at common law. Note, however, that most states by statute make parents liable for the willful and intentional torts of their minor children up to a certain dollar amount, for example, $10,000. And child acting as agent for the parents and parent liable for their own negligence. Courts may impose vicarious liability if the child committed a tort while acting as the agent for the parents. The parents may be held liable for their own negligence in allowing a child to do something, for example, use a dangerous object without proper instruction. Furthermore, if the parent is apprised of the child's conduct in the past occasions showing a tendency to injure another person or property, they may be liable for not using care and exercising control to mitigate such conduct, for example, by allowing the child play with other children that they have a history of attacking. Tavern keepers. What is this called? Dram Shop Act. Many states, in order to avoid the common law rule, have enacted dram shop acts. Such acts usually create a cause of action in favor of the third person injured by the intoxicated person. Several courts have imposed liability on tavern keepers even in the absence of a dram shop act. This liability is based on ordinary negligence principles, the foreseeable risk of serving a minor or obviously intoxicated adult rather than vicarious liability. So, vicarious liability table is on page 63. It summarizes those we just talked about: employee, independent contractor, partner, or joint venturer, driver of automobile, bailee for bailor, patron of a tavern, and parent for child. So, employer vicariously liable for the tortious acts within the scope of the employment relationship. Employer of independent contractor not vicariously liable for, unless the activity is inherently dangerous or the duty is non-delegable on public policy grounds. I feel sick. Owner or other partners or joint ventures vicariously liable if tortious act within the scope and course of partnership or joint venture. Owner of automobile not vicariously liable unless jurisdiction has family car doctrine or permissive user statute. Bailor is not vicariously liable, and the parent is not vicariously liable except for limited statutory liability for willful and intentional torts. And tavern keeper not vicariously liable in absence of a dram shop act. Note, even if the related party is not vicariously liable, they may be liable for their own negligence. For example, negligent selection of independent contractor, negligent entrustment of automobile, and negligent supervision of child. That would be direct liability, not vicarious liability. Multiple defendant issues: joint and several liability, satisfaction and relief, and contribution and indemnity. Joint and several liability. Under the traditional common law rule, when two or more negligent acts combine to approximately cause an indivisible injury, each negligent actor will be jointly and severally liable, that is, liable to the plaintiff for the entire damage occurred. If the injury is divisible, each defendant is liable only for the identifiable portion. Defendants acting in concert. When two or more defendants act in concert and injure the plaintiff, each is jointly and severally liable for the entire injury. This is so even if the injury is divisible. Statutory limitations. Many states have abolished joint liability in cases based on fault, either one, for those defendants judged to be less at fault than the plaintiff. You can turn that off. I don't need that. Less at fault than the plaintiff. Or two, if all defendants regarding non-economic damages. In these cases, liability were proportional to the defendant's fault. Satisfaction and release. Satisfaction. Recovery of full payment is a satisfaction. Only one satisfaction is allowed. Until there is satisfaction, however, one may proceed against all jointly liable parties. Release. In most states, a release of one tortfeasor does not discharge other tortfeasors unless it is expressly provided for in the release agreement. Contribution and indemnity. Contribution and indemnity are doctrines that determine how joint tortfeasors allocate between them the damages they must pay to a successful plaintiff. Contribution. The rule of contribution allows a defendant who pays more than their share of damages under the joint and several liability to have a claim against other jointly liable parties for the excess. In other words, it apportions responsibility among those at fault. Methods of apportionment. Comparable contribution. Most states have a comparable contribution system whereby contribution is imposed in proportion to the relative fault of the various defendants. Equal shares. In a minority of states, apportionment is in equal shares regardless of degrees of fault. Contribution tortfeasor must have liability. The contribution defendant must be originally liable to the plaintiff. If the contribution defendant has a defense that would bar liability, such as intra-family tort immunity, they are not liable for contribution. Not applicable to intentional torts. Contribution is not allowed among intentional tortfeasors. Indemnification. Indemnification involves shifting the entire loss between or among tortfeasors. Indemnity is available in the following circumstances. In vicarious liability situations, under strict products liability for the non-manufacturer. Period. Next page. Comparative contribution. As noted above, most comparative negligence states have adopted a comparative contribution system where contribution is in proportion to the relative fault of the various defendants. This approach also supplants indemnification rules based on identifiable differences in degree of fault. Loss of consortium and tortious interferences with family relationships and tort immunities, and survival and wrongful death are my next topics. Between spouses, either spouse may bring an action for indirect interference with consortium and services caused by the defendant's intentional or negligent tortious conduct against the other spouse. Parent-child. A parent may maintain an action for the loss of a child's services and consortium as a result of the defendant's tortious conduct, whether intentional or negligent. A child, however, has no action in most states against one who tortiously injures their parent. Nature of action. Actions for interference with family relationships are derivative. Hence, any defense that would reduce or bar recovery by an injured family member also reduces or bars recovery for interference with the family relationship. Survival and wrongful death. Survival of tort action. Survival acts allow one's cause of action to survive the death of one or more of the parties. The acts apply to actions involving one or more of the parties. The acts apply to actions involving torts to property and torts resulting in personal injury. However, torts invading intangible personal interests, for example, defamation, invasion of right of privacy, malicious prosecution, expire upon the victim's death. Wrongful death. Wrongful death acts grant recovery for pecuniary injury resulting to the spouse and next of kin. A decedent's creditors have no claim against the amount awarded. Recovery is allowed only to the extent that the deceased could have recovered in an action had they lived. Hence, the decedent's contributory negligence reduces the wrongful death recovery in comparative negligence states. Similarly, a potential beneficiary's contributory negligence reduces their share of the recovery in comparative negligence states. Tort immunities. Intra-family tort immunities. Under the traditional view, one member of a family unit cannot sue another in tort for personal injury. Today, many states have abolished spousal immunity. A slight majority have also abolished parent-child immunity, but generally do not allow children to sue merely for negligent supervision. Those that retain parent-child immunity do not apply it in cases alleging intentional tortious conduct or automobile accident cases to the extent of insurance coverage. Governmental tort immunity in varying degrees. Federal, state, and municipal tort immunity has been eliminated. Where it survives, immunity attaches to government, not proprietary functions. Federal government. Under the Federal Tort Claims Act, the United States has waived immunity for tortious acts. However, immunity will still attach for assault, battery, false imprisonment, false arrest, malicious prosecution, abuse of process, libel and slander, misrepresentation and deceit, and interference with contract rights. Immunity is also not waived for acts that are characterized as discretionary, those involving considerations, political, economic policy, usually made by senior officials, acts termed ministerial. Those performed at the operational level of government are not immune from liability. State governments, local governments, immunity of public officials, and charitable immunity. The majority of jurisdictions have eliminated charitable immunity. As for states and local and public officials, most states have substantially waived their immunity to the same extent as the federal government. Hence, immunity is retained for discretionary acts and for legislative and judicial decision making. Local governments, about half of the states have abolished municipal immunity to the extent. As for the state government, where municipal immunity has been abolished, the public duty rule provides that a duty owed to the public at large is not owed to any particular citizen absent the special relationship between the governmental body and the citizen. Thus, a city will not be liable to one whose house burns if the fire department negligently fails to respond to an alarm. But the provision of the fire protection services is a public duty where municipal immunity still exists. Contrast governmental functions that could only be performed adequately by the government, and proprietary functions that might as well have been provided by a private corporation. Courts limit application of sovereign immunity by not granting it for proprietary functions. Immunity of public officials. Public officials carrying out official duties are immune from tort liability for discretionary acts done without malice or improper purpose. Liability attaches, however, for ministerial acts. So last module 16, defamation and invasion of privacy and other harm to economic and dignitary interests. Defamation. The elements of defamation are a defamatory statement that specifically identifies the plaintiff, published to a third party, damage to the plaintiff's reputation, falsity of the defamatory language, and fault on the part of the defendant. Breaking this down, the defamatory statement is one tending to adversely affect one's reputation. A statement of opinion is actionable only if it appears to be based on specific facts, and an express allegation of those facts would be defamatory. Name calling is insufficient. Inducement and innuendo. If the statement is not defamatory on its face, the plaintiff may plead additional facts as inducement to establish defamatory meaning by innuendo. Living person requirement. Any living person may be defamed. Defamation of a deceased person is not actionable in a limited sense. A corporation, unincorporated association, or partnership may be defamed, for example, by remarks to its financial condition, honesty, integrity, etc. Statement must specifically identify the plaintiff. The plaintiff must establish that a reasonable reader, listener, or viewer would understand the defamatory statement referred to the plaintiff. Colloquium. If the statement does not refer to the plaintiff on its face, extrinsic evidence may be offered to establish that the statement refers to the plaintiff. This is known as pleading colloquium. Group defamation. If the defamatory statement refers to all members of a small group, each member may establish that the statement specifically identifies them by alleging that they are a group member. In other words, every member of that small group wins. If a statement only refers to some members of a small group, the plaintiff can recover if a reasonable person would view the statement as referring to the plaintiff. If the plaintiff is about a large group, no member can prove that the statement specifically identifies them. In that case, no one wins. Publication. Publication means communication of the defamation to a third person who understands it. Such publication can be made either intentionally or negligently. It is the intent to publish, not the intent to defame, that is the requisite intent. Each repetition is a separate publication. However, for magazines, newspapers, etc., most states have adopted a single publication rule under which copies are treated as one publication. Who may be liable? Primary publishers, for example, newspapers, TV stations, etc., are liable to the same extent as an author or speaker. One who repeats a defamation is liable on the same general basis as the primary publisher, even if she states the source or makes it clear that she does not believe the defamation. One selling papers or playing audio files is a secondary publisher and is liable only if he knows or should know of the defamatory content. An internet service provider is not treated as a publisher when a user of its service posts discriminatory content. Damage to plaintiff's reputation. The type of damage the plaintiff must prove depends on the type of defamation, libel, or slander involved. Damages generally are presumed under the law of libel. In some slander cases, the plaintiff must prove that they suffered special damages. That is, they must have suffered some pecuniary loss in order to recover anything. But once the plaintiff has proved special damages, they may recover general damages as well. Libel. Libel is a defamation that is embodied in permanent form. It is often a written or printed publication of defamatory language. Defamation in radio and television programs is treated by most courts today as libel. The plaintiff typically does not need to prove special damages to recover, and general damages are presumed. A minority of the courts will presume general damages only if the statement is defamatory on its face, libel per se, and require proof of special damages if the statement requires reference to extrinsic facts to establish its defamatory nature, libel per quod. That one I don't know. That Latin. Quod. Slander. Slander is spoken defamation. A plaintiff must prove special damages unless the defamation falls within one of the slander per se categories. And these are defamatory statements that adversely affect the plaintiff's business or profession, state that the plaintiff has committed a serious crime. This includes most common law crimes and sometimes referred to as crimes involving moral turpitude. And impute that the plaintiff is engaged in serious sexual misconduct and state that the plaintiff has a loathsome disease. Falsity. Under traditional common law, the plaintiff did not have to prove that the statement was false. Rather, the defendant was obliged to prove the truth as a defense. Many states have altered that rule, however, and now require the plaintiff to prove falsity as part of the case in chief. Even in states that still follow the traditional rule, the plaintiff must prove falsity in any case where the plaintiff is constitutionally obligated to prove fault. Fault on defendant's part. A majority of states require showing of fault on the part of the defendant. In addition, there are constitutional limitations depending on the plaintiff's status. Public official or figure must prove actual malice. Under the New York Times or Sullivan rule, actual malice must be proved in defamation cases brought by public officials and public figures. What constitutes a public figure? A person becomes a public figure by achieving pervasive fame or notoriety, or by voluntarily assuming a central role in a particular public controversy. Definition of actual malice. Actual malice, as defined by New York Times and Sullivan, is knowledge that the statement was false or reckless disregard as to whether it was false. This is a subjective task. The defendant's spite or ill will is not enough to constitute malice. Deliberate altering a quotation may constitute malice if the alteration causes material change to the meaning conveyed by that quotation. Private persons must prove negligence if matter of public concern. Under Gertz versus Welch, when a private person is the plaintiff, only negligence regarding the falsity must be proved if the statement involves a matter of public concern. If the statement is not a matter of public concern, if the state constitutional restrictions do not apply. But note that many states require a showing of negligence as a matter of state law. If the defendant is negligent, only actual injury damages are recoverable. However, if actual malice is found, damages may be presumed and punitive damages allowed. What constitutes actual injury and what is a matter of public concern? Actual injury is not limited to economic damages. It may include damages for impairment to reputation and personal humiliation as long as the plaintiff presents evidence of such damages. In other words, no presumed damages. What is a matter of public concern? To determine whether the defamatory statement involves a matter of public concern or private concern, the courts will look at the content, form, and context of the publication. Defenses to defamation: consent. Consent is a complete defense. The rules relating to consent to intentional torts apply here. Truth, privilege, mitigating factors. In cases where the plaintiff is not obligated to prove falsity of the statement as part of their own case, the defendant may prove truth as a complete defense. Privilege. Absolute privilege can never be lost. The defendant may be protected by an absolute privilege for the following: communication between spouses, remarks made during judicial proceedings by legislators during proceedings, even if not related to the proceedings, by federal executive officials in compelled broadcasts. Qualified privilege can be lost through abuse. A qualified privilege arises only when there is a public interest in encouraging candor. The defendant bears the burden of proving the privilege exists. Whether a speaker has a qualified privilege will be determined on a case-by-case basis. Qualified privilege may be lost if the statement is not within the scope of the privilege or it is shown actual malice. Some possible examples include references and recommendations, reports of public hearings and meetings, statements made to those who are to take official action, for example, statements made to the parole board about a prisoner, and statements made to defend one's own actions, property, or reputation. Mitigating factors: for example, no malice, retraction, anger for the speaker provoked by the plaintiff may be considered by the jury on the damages issue. They are not defenses to liability. Invasion of right to privacy. There's appropriation, intrusion, false light, and public disclosure of private facts. Little section until we get to misrepresentation, negligent misrepresentation, and interference with business relations. So there's only like 4 more pages. 1, 2, 3. I think there's a total of 4 more pages. The right of privacy is personal right and does not extend to members of a family, does not survive the death of a plaintiff, and is not assignable. The right of privacy is not applicable to corporations. The invasion of the plaintiff's interest in privacy must have been proximately caused by the defendant's conduct. The plaintiff need not plead and prove special damages. Emotional distress and mental anguish are sufficient damages. This tort includes 4 types of wrongs: appropriation of the plaintiff's picture or name, intrusion for commercial gain, intrusion on the plaintiff's affairs or seclusion, publication of facts placing the plaintiff in a false light, and public disclosure of private facts about the plaintiff. Appropriation of plaintiff's picture or name: it is necessary to show unauthorized use of a plaintiff's picture or name for defendant's commercial advantage. Liability is generally limited to advertisements or promotions of products and services. Mere economic benefit to the defendant, not in connection with promoting a product or service, by itself is not sufficient. Intrusion on plaintiff's affairs or seclusion: this claim forbids such acts as eavesdropping, spying, interception of phone calls or electronic communications, and other similar conduct. The act of prying or intruding must be highly offensive to a reasonable person. Furthermore, the thing into which there is intrusion must be private. Photographs taken in public places are not actionable. Publication of facts placing plaintiff in false light. False light exists where one attributes to the plaintiff views they do not hold or actions they did not take. The false light must be something highly offensive to a reasonable person under the circumstances. For liability to attach, the defendant must circulate the statement to the public at large. Sharing the statement with only one or a few persons will not be sufficient to trigger liability. First Amendment limitation. It is a matter of public interest. Actual malice on the defendant's part must be proved. Public disclosure of private facts about the plaintiff. This wrong involves public disclosure of private information about the plaintiff. For example, matters of public record are not sufficient. The public disclosure must be highly offensive to a reasonable person of ordinary sensibilities. Liability may attach even though the actual statement is true. First Amendment limitations probably apply if the matter is of public interest. Defenses. Some defenses of the right to privacy actions are consent and the defamation privilege defenses. Truth generally is not a good defense, nor is inadvertence good faith or lack of malice. Misrepresentation. Intentional misrepresentation, fraud, deceit. To establish a prima facie case for intentional misrepresentation, this requires misrepresentation of a material past or present fact. Scienter. When the defendant made the statement, they knew or believed it was false or that there was no basis for the statement. By the way, past and present fact in the misrepresentation definition means that you can't make a misrepresentation of future facts because they're not facts. The defendant made the statement, they knew or believed that it was false or that there was no basis for the statement. Intent to induce the plaintiff to act or refrain from acting in reliance upon the misrepresentation. Causation, actual reliance, justifiable reliance, and damages and actual pecuniary loss. Damages. Okay. The plaintiff must suffer actual pecuniary loss. There are no defenses to intentional misrepresentation. No general duty to disclose. There is no general duty to disclose material fact unless the defendant stands in a fiduciary relationship to the plaintiff, is selling real property, and knows the plaintiff not reasonably discover the plaintiff material information about the transaction, or 3, has spoken in their utterance to seize the plaintiff. Physical concealment of a material fact may also constitute a misrepresentation. Okay, so there's no defenses if intentional. And what are these? No general duty to disclose. So a duty only arises if it's a fiduciary relationship, caveat emptor, like plus latent defects and concealment. Third-party reliance. If a third party relies on the defendant's misrepresentation, the defendant will be liable if they could reasonably foresee that the third party would so. Reliance on opinion. Reliance generally is justifiable only on representations of fact, and the plaintiff is under no obligation to investigate the fact. Reliance on opinion is justifiable only if the defendant offering the opinion has a superior knowledge of the subject matter. Negligent misrepresentation. A prima facie case for negligent misrepresentation requires misrepresentation in a business or professional capacity breach of duty toward a particular plaintiff, causation, justifiable reliance, and damages. Generally, this action is confined to misrepresentations made in a commercial setting, and liability will attach only if reliance by a particular plaintiff could be contemplated. For example, for negligent misrepresentation, foreseeability that the statement will be communicated to a third party does not make the defendant liable to the third party. Last page, interference with business relations. To establish a prima facie case for interference with business relations, the following elements must be proved: existence of a valid contractual relationship between the plaintiff and a third party, or valid business expectancy of the plaintiff, the defendant's knowledge of the relationship or expectancy, intentional interference by the defendant inducing a breach or termination of the relationship or expectancy, and damages. Privileges. The defendant's conduct may be privileged if it is proper attempt to obtain business for itself or protect its interests. A privilege is more likely to be found if the defendant, 1, interfered only with the plaintiff's prospective business rather than the existing contracts, 2, used commercially acceptable means of persuasion rather than illegal or threatening tactics, 3rd, is a competitor of the plaintiff seeking the same prospective customers, and 4th, has a financial interest in or responsibility for the third party or is responding to a third party's request for business advice.